Thank you so much for joining me for this webinar. My name is Sara Shikhman. Many of you may know me. I'm a healthcare attorney. I've been an attorney for about 18 years and spent a lot of my time building lots of different types of businesses. So even before starting my firm in 2019, I helped start lots of different businesses, from a multi-million-dollar e-commerce company to a med spa that we built from one room in one state to 5 different states and 12 locations, to a aesthetic software company, started a med spa in New York. So I've done a lot of different things, both as a med spa operator and owner and as an attorney. And I think I have a good understanding of the unique challenges that a lot of people face in this industry. And I love to do these webinars to just talk about some of the challenges and how I think we can approach them, and some of the compliant legal strategies to take to continue operating a profitable business and at the same time be compliant with the law. So this webinar is going to be talking about GLP-1s, but there are lots of other changes happening in the law that we'll cover a little bit as well, but the main focus will be about GLP-1. So first things first, what are GLP-1s and what's the big deal? Just by way of background, we'll spend like 1 minute on this so we could really jump into things. GLP-1s are special types of medications that essentially help people lose weight. For a while the brand name drugs were on the shortage list, the FDA allowed compounding pharmacies to make essentially copies of the brand name drug. This is a limited thing that happened, but it happened for quite a long time because these drugs are extremely popular and lots of patients need them, and the companies could not fill all the demand that they had. So this happened for, I think, about 2 years. And then as Eli Lilly and Novo Nordisk increased their capacity, they filed with the FDA and they said, hey, stop this. You're letting our people compete with us. We have patents on these drugs. And the FDA removed them off of the shortage list. That's the summary. And what happens if once something is removed off the shortage list, people like compounding pharmacies can't make what's considered essentially copies. And in this webinar, we're going to talk about, well, what is a copy? Because I know a lot of places are sending different emails and different materials saying, well, we're adding X ingredient to this, or we're changing the dose. That's not a copy, that's compliant. We'll talk about that approach and whether that's risky or not. So some of us may be familiar with compounded Kybella or PCDC, or deoxycholic acid, as some people may call it, which is kind of a similar thing to this, where AbbVie has a patent on Kybella, but then compounding pharmacies have a way to make a very similar or almost an exact copy of it. And how come AbbVie doesn't go after people, right, for compounded Kybella, for example? Well, the reason for that is because it all comes down to, unfortunately, money, and you have to follow the money when it comes to things like this. So here, these drugs, like Ozempic, are predicted to give these companies $50 billion in revenue over the next 5 years or more, whereas Kybella is not a blockbuster drug, let's call it that, right? And so as long as you're buying Botox from AbbVie, they're not really going to care so much about you getting compounded Kybella, because that's not the drug that they're making the money from. But in this case, what's happening is these pharmaceutical giants are saying this is their biggest drug of all time, or close to it. And so they're happy to spend billions of dollars enforcing their rights to it. So in December 2024, the FDA said, okay, Tirzepatide is off the shortage list. In February 2025, Semaglutide was taken off the shortage list. So what does that mean? Well, what that means is the FDA is not there with thousands of people coming after people. The pharmaceutical companies are. So companies like Eli Lilly and Novo Nordisk are saying, hey, we're going to spend $1 billion going after people for this. We're going to send cease and desist letters to thousands of companies. We've had, I would say, over 100 people, companies that we know of, many of whom are our clients, get letters like this. So it's not just like one per state, or only the big companies, or only someone super visible. Tiny places that don't really even advertise are sometimes getting these. And what's happening is when people are not responding to these letters, it's not like Eli Lilly just says, okay, thanks so much for not responding, bye. They keep escalating the case. So we've had situations where a company received a letter, a month later, another letter, a month later, a lawsuit was filed, and then now these protracted negotiations are happening where the pharmaceutical companies are asking for hundreds of thousands of dollars, even if our clients can show that they really didn't make any money on this, or maybe they prescribed it to only one person, or they prescribed it to two people. So it's getting really serious. And from the pharmaceutical company's perspective, they're saying, well, we're okay spending $1 billion to go after this. And I don't want to put words in their mouth, but this is what I'm seeing in the industry, seeing so many people get these kinds of letters, and also seeing the lawyers behind these letters really not wanting to negotiate, really taking a super aggressive approach. And what's interesting is these letters are really like form letters. It's the same letter that most people are getting. So it's not like it's costing Novo and Eli Lilly anything extra to sue 10,000 people versus 1,000 people. They have companies, I'm sure, on retainer where they're really going after this aggressively. So it's not really the FDA that's going after people today. It's law firms hired by these pharmaceutical companies. And so when I talk to people about compliance and what to worry about, you really have to worry about the people who have like the biggest stake in the game, right? The people who are willing to spend the millions of dollars to enforce their rights. And here, it's not the government agencies, it's really the pharmaceutical companies themselves. So, like I said, Eli Lilly invested about $3 billion to develop its drug. They think it's going to be a $20 billion annual revenue drug. They've already sued a couple of pharmacies, and I don't think they're stopping. I know that the pharmacies have written back and said they're going to fight. But at the end of the day, I think that it's going to be really, really hard for them to fight someone who has a multi-billion-dollar budget. I think that in this case, over time, the compounding pharmacies will give up. And what matters to our industry is that what will happen is these compounding pharmacies will get subpoenas for records, and they are going to release their customer list. And so even if today you may be doing things under the radar and nobody knows, because things can get subpoenaed, eventually, if you're doing things that you shouldn't be doing, there's this big risk of getting in trouble. And I say this because my job, and I take this job super seriously, is I want to help protect people from risk that doesn't make sense. So we're going to talk about what kind of risk makes sense. And that calculation is different for every practice. And it is a calculation. I really believe that, because in this case, it's not like people are really getting harmed by these drugs, right? There's nothing where the compounded drugs have been shown to have more adverse events or anything like that. Not really. It's more about following the money and thinking about, okay, what's at stake here? What's going to be my expected revenue with this? What do I do to maintain my client base? What do I do to not upset my clients and meet my practice goals? Eli Lilly has already sued several compounding pharmacies and several practices. And notice that in these lawsuits, they didn't say, okay, well, you were producing an exact copy and that's bad. They said, even if you were producing copies, like for example, for Strive, compounded Tirzepatide with added vitamin B12. So it's not like these pharmacies were producing it by itself. They're producing it with an added ingredient. So Empower had Tirzepatide as a pill and an injectable with vitamin B3, and Strive had it with B12 or glycine. So two things important here. Just because you are adding an ingredient to these compounded versions does not make the practice compliant, unfortunately. I wish it would, but it doesn't. And then the other thing is changing the dose doesn't make it compliant either. So a lot of people have asked me, well, what if I microdose? What if the dose I need for my patients is not commercially available? The pharmaceutical companies are still taking the position that, okay, well, that all those things may be true, but that is still you administering a copy of our drug. They said that they intend to send 50 cease and desist letters. I've seen over 100 already. So I'm sure that really the real number is probably in the thousands. I think Strive's response to this is a good one and a strong one. But ultimately, because Strive is a much smaller entity than these pharmaceutical companies, I don't think that at the end of the day, they are going to be successful. I could be wrong, but from doing this for almost 20 years, being a lawyer, I think at the end of the day, it all comes down to the negotiating power of the companies and how much budget people are willing to put toward it. I have clients who the only thing that they do is compounded GLP-1. So they may be an online prescriber, all 50 states, doing GLP-1s. And so for them, if they're not able to do the compounded version, it's the decision of, okay, do we fight this or do we go out of business? Or are we okay with having a lawsuit from one of the pharmaceutical companies spending $200,000 on legal costs, but we expect to make 2 million or we expect to make 5 million, right? So it's a financial calculation. So for someone who's expecting to make, let's say, 10,000 in revenue for this or 50,000 in revenue, the expected legal cost of defending a complaint will probably be at least 25 to 50,000. So just have to keep in mind that if you're going to go and take the legal risk, just make sure that it's justified based on what your expected revenue is, because sometimes it may not be justified. But like I said, I have clients who have big practices, 50 state practices, where they're saying it's okay for them to take on this risk. So it just depends on what your risk tolerance is. Of course, there's a lawsuit where the compounding pharmacies are fighting back, and the trade organization that compounding pharmacies are part of sued the FDA. But the court, at least for now, agreed with the FDA. So the court did not say, well, while this lawsuit is going on, everyone is exempt, don't worry about it. The court said, no, the FDA is right. People cannot be compounding these drugs right now. So really important to understand that. And I do see there have been a lot of communications around this from lots of places that say we have the compliant solution to GLP-1. So my response to that is potentially wonderful. Ask them in writing, will you defend me if I get sued based on administering this to my patient? And see what they say. See if they send you a disappearing message, or if you never hear from them again, or if they, if the power goes out and their internet doesn't work anymore, and some weird thing happens, right? I think that a lot of times I understand how compounding pharmacies' main business is compounding GLP-1s, and now they can't really legally be doing that they would try to work around that as much as they can until they can't anymore. But you don't want to be subject to their risk. So if they're willing to, in writing, tell you don't worry about it, what they're doing is legal, make sure to get that in writing from them. And if you've gotten one of these letters from these pharmaceutical companies, make sure not to ignore it, because they don't just go away. They have a whole sequence that they do where they send another letter and sometimes a third letter, and then they file a lawsuit. And defending these kind of lawsuits, like I mentioned, is very expensive. So make sure that if you're going to fight back, that you don't just throw the letter in the garbage and hope they forget about you, because they're not going to forget. So, like I said, the court sided with the FDA. They said, no, we are not lifting the order that the FDA did, which said we're taking these drugs off the shortage list. The order essentially says that smaller compounding pharmacies have to cease production of Tirzepatide. That happened back in March 19th. So Tirzepatide, as of now, we're in April, cannot be legally compounded in any way. Small pharmacy, big pharmacy, individual patient prescription, in-office use, whatever the use and whatever the prescription type, it's not supposed to be done anymore. The Outsourcing Facilities Association, which is the Association of Compounding Pharmacy, they did file an appeal, but there are lots of hearings that are happening in this case. There was one on March 27th. There's going to be one in May. There are going to be more hearings, but right now nothing has been determined. So just because an appeal has been filed, it doesn't mean that the case has been thrown out or that the older decision doesn't have any value. It just means that potentially something can get reversed. But the standard for something to get reversed on appeal is super hard to meet. The judge must have made a big mistake. It can't just be a different person would have a different decision here. It's more like the judge must have really erred and not considered some really important piece of the evidence. So most likely it's not going to get reversed. So let's talk about the liability and what you can do to mitigate it. One thing you can do is get these written assurances from wherever you're getting your medication. So for example, some people are marketing medications that are actually just for research use. Right, so not Tirzepatide, not Semaglutide, but some of the other newer ones that have not been FDA approved in any way by any pharmaceutical company. There are additional risks with doing those kind of medications too, because something for research use technically should not be used on humans outside of trials. And so you want to put that in your patient consents that these things are for research use, they have additional risks, and you want to make sure that your patients understand that there are these additional risks for getting these medications. So that way, at least if they sign a consent and you inform them that this is for research use, you're in a little bit of a better place. On the other hand, if you're getting these medications, you would write back to whoever's supplying this to you and you would point blank ask them, okay, thank you for supplying this to me. This is for research use. So is this safe for human use? And see what they say. Maybe you'll get some of them to tell you in writing that this is safe, and then maybe that'll help you have a little bit more legal protection. Now, it's not going to cover you 100%, but every 1% to be practical, right? Every 1%, it'll help you a little bit to be compliant. There are laws that are pending about GLP-1 medication. I used one in Texas as an example because we've been talking a lot about other development in Texas as well, which we'll talk about. So there's a bill that would require health plans to cover GLP-1s. It would take effect September 1st. It hasn't been passed. It's not close to being passed, but it could pass. And other states have similar bills. And then speaking of Texas, a lot of people have been talking about other bills in Texas that are potentially going to pass. So at any given point in time, there are 1 to 5 bills in nearly every state going through some kind of process. Either they've just been introduced, or they're in committee, or they're being considered by the House or the Senate, or maybe they're waiting signature by the government. But for a bill to pass, it's quite a long process, and most bills do not pass. The kinds of bills that we see getting passed most recently are things like giving full practice authority to nurse practitioners, or in some states, giving full practice authority to physician assistants. But most bills restricting practice have not been, and typically they happen as a result of some adverse event. So what can we do as an industry to prevent these bills from getting passed? Well, reduce the instance of adverse events. And that's super hard to do, right? How do we do that? More education, more training, more collaboration, more webinars like this when we're sharing our resources. Because the more adverse events there are, the more regulation there will be. The other thing is there are very strong lobbying groups for physicians, for nurse practitioners, for PAs, for lots of other providers. So being part of those lobbying groups and supporting them is another way. And then of course, messaging your state senator and saying how you feel about potential changes also helps. So you could figure out on your state Senate website who your local senator is and send them a message about any legal developments. We send out alerts all the time about potential bills, but the reality is there are lots of bills around the country right now that would change scope of practice of different providers or change how medical directors have to oversee things. None of them are super close, like a month away from getting passed today that I've seen. At the same time, should there be some very serious adverse event, like the one that happened in Texas a few years ago where someone died, right away things get sped up. So as a result of that, one of those bills may pass, the one talking about what unlicensed providers can and cannot do in Texas. But some of the others that have been proposed there, talking about how a good faith exam, for example, can only be done by a physician or something like that, those are really unlikely to pass in the current climate anyway. We have such a big shortage of providers in this country that it would make it impossible to have clinics in rural places and other things like that. So I'm not extremely worried of a lot of these bills passing, and I am not sure that GLP-1s are going to be covered by insurance, but a lot of states do have bills now proposing that they should be, so perhaps they will be. Another thing to watch out for is DEA and telemedicine prescribing. So right now, and ever since COVID, there was a relaxation of this rule that previously that said, hey, if you're prescribing controlled substances, like, for example, testosterone, you have to see the patient in person. And then after that, you can do it by telemedicine. But first, you have to do it in person. And that used to be the rule. But that rule went away during COVID, and it's been extended for several years after. So right now, people can get controlled substances like hormone replacement treatments like testosterone online. There are lots of proposals to change that at the end of this year. Again, I don't think that it's likely to change as early as at the end of this year, but if we were to have a couple of patient deaths that are well publicized, then I do think that things will change. It's interesting, our system is very reactive to things like this, and it's interesting to note that like the actions of one or two people in our industry could really make a big difference for lots of people in the industry. So we have this like shared responsibility for safe practice. Otherwise, we have more and more regulations coming. Again, there are exceptions. So if the patient has a legitimate need, if they are living in a very remote area, likely you'll still be able to prescribe controlled substances to them, but there may be other exceptions added to the law, or the law may get tighter. As everyone has seen, we're kind of operating in uncharted territory when it comes to regulations these days. So things may change, but it seems like the regulation of our industry is not the highest priority of the current administration. So that's good. But at the same time, things can always change. There was recently a case in New York where someone did plastic surgery. Well, I don't know if I guess a butt implant it would be considered plastic surgery. Let's say surgery in somebody's home in Queens, and the person ended up brain dead. So because of things like that, more regulation comes. So we have to be vigilant, and if we see unsafe practice from other people, make sure to try to get the people to understand that it's super dangerous, not just for them and their patients, but for the whole industry as a whole. One more thing about the DEA and telemedicine prescribing. So there are exceptions to telemedicine prescribing, even if the new law or the old law comes back into effect. So if the old law comes back into effect, and it's supposed to December of this year, then you will not be able to prescribe controlled substances anymore unless you fit into one of these exceptions, like you're a psychiatrist, you're a pediatrician, you're a neurologist. So there are some exceptions to this, and there always are in the law in most parts, but just make sure to ask specifically about your situation, right? Like what practice you're in, what state you're in, and what you have to do. Because also you have to make sure you have a DEA registration, that it is tied to the correct address and the correct provider. Because the DEA registrations are not just for your practice, they are based on each practice location, each provider. So just make sure that if you are prescribing anything controlled, like testosterone, that you have a DEA registration, even if right now you're prescribing it by telemedicine. So what does this mean for med spas and other types of practices? What should people do about GLP-1s today? I wish sincerely and truly that I had a better solution that was 100% legal. But the only real legal solution today is to migrate someone to one of the brand name medications. All of the other solutions are not 100% compliant. So it depends on somebody's risk, right? No business is 100% risk free. If your attorney is telling you like you can't have any risk in this situation, then they're a bad attorney because they're basically telling you to go out of business. At the same time, you want to take risks that make sense for you. So for your practice, if 100% of your revenue is GLP-1s and you have a high risk tolerance, then you may believe the words of the compounding pharmacy that tells you this is 100% safe and continue, but knowing that deep in your heart, it's not fully compliant and it may be very expensive for you to be in a lawsuit. Personally, think it's very risky. So my clients ask me many times, they say, hey, if you were me, what would you do? And I say, I would transition my patients to the brand name medications, and I would develop a new weight management program that's like a bundle price and includes lots of things, not just the GLP-1 injection. So to use it as an opportunity to build something unique to your practice where people are not just coming in for one thing and it's a commodity, but where they're coming in for a real experience with you, with your providers, with your unique equipment and skills and whatever package you have, so that it's not like, okay, $249, and then the client goes, okay, yours is $249 and some others is $239. That's not great. At the same time, this is not great for patients because the price for patients is going to go up. Right now, I think the Eli Lilly direct price starts at $349 a month or something like around there. So the prices are higher than a lot of practices were charging, for sure. So what can happen next? There is a possibility that the FDA is going to issue new guidance or put some of these things back on the shortage list. Right now, there is still a global shortage for these drugs. The global population is large, and that global shortage may affect the US, but it's not guaranteed, and there hasn't been any signaling that this is what's going to happen. These companies are super reliant on their patents, and they are in the government's ear saying, hey, we invested $3 billion developing these drugs. If you let people copy us during the period that we have our patent, then what motivation do we have to develop new drugs? It's hard for the government to argue with that. There are lots of industry associations trying to file lawsuits and trying to help people respond. At the same time, though, there hasn't been any successful response, meaning I have not seen the pharmaceutical companies back down. We've made lots of different arguments to them. We've tried to say, sometimes it's a mistake. This aesthetics practice only prescribed this to one person. Have mercy, but these people are not very merciful. They're interested to shut any competition down. So what can people do today, tomorrow, this week, this month to take some steps toward compliance? First of all, review your supply chain. Ask your pharmacies or wherever you're getting these medications, are you compliant with FDA regulations, and see what they say to you. Asking them and not getting a response is better than never asking them at all. For your patients, make sure to update your consent forms to reflect the current status of these medications. So for example, if you're continuing to prescribe a compounded version to someone, and this is really important. So if you're continuing to prescribe a compounded GLP-1, make sure you have a medical reason for doing so and that it's documented in the medical record for that patient. Of course, though, you can't have, if you have 100 patients, 100 of them have this unique medical reason to have a compounded medication. That would probably be fraud and you can get into a lot of trouble. But if some small percentage of your patients truly need them, then make sure that it's documented. When your patients talk to your providers about these drugs, make sure that your providers are using the right language. You should not say anywhere that, for example, compounded Tirzepatide is FDA approved. These compounded drugs are not FDA approved. As a matter of fact, in your consents and in your communications and on your website, you should make sure to say that they're not FDA approved. And we and whoever else you use for compliance can definitely keep you appraised of any developments, but there isn't going to be a perfect answer for the GLP-1s question for a while. I mean, we're monitoring it every day. We have several of my colleagues that are in Texas and are looking into this legislation literally from where they live, but it's hard because it's such a big change in our industry and we're really up against two pharmaceutical giants for whom these products are their best sellers, perhaps the best sellers of all time. It's going to be a hard transition in some ways. At the same time, it's going to be a transition that forces everyone to rethink the business proposition. If you're just selling the same thing that everybody else is selling, then it's really hard to deliver value and create a unique patient experience. So make sure that whatever compounds that you're providing to your clients, that it's documented why you're doing that and that you're not doing anything beyond the use by date. We've had a few situations where clients noticed that the date on the vials had passed and filed complaints against their providers, who sometimes were friends and family. At the same time, we've had clients like med spas where one of their staff members said, hey, what you're doing is not compliant. I noticed the dates on our drugs have expired. So make sure that you're not using anything expired. Patients are getting very smart about these things. And so if you told someone that something is FDA approved and it's not, they're also getting upset by the situation and they're saying that they were misled. So if you are continuing to do GLP-1s, make sure that you have lots of disclosures in your consents about why you're doing it, what their FDA approval status is, that they're not approved, and what alternatives exist to your client so your client can make an informed decision. So key deadlines, right? Today is April 22nd. Right now, No more Tirzepatide. It's not legal to be compounded anymore. Semaglutide today, state licensed pharmacies under 503A, as of today, they're not supposed to compound it anymore. As of May 22nd, the bigger pharmacies are also supposed to stop compounding it. So what does that mean? It means that right now there still may be a supply of semaglutide, especially from some pharmacies, but by May 22nd, there probably will be much less. So if you're taking the position that you want to continue doing this for as long as possible, May 22nd will be the date to really keep in mind. In writing, have the conversation with your suppliers. Ask them, is what you're providing me FDA compliant? And if they say yes, perhaps ask them why. Don't just take their word for it. And if they're sending you a disappearing message or leaving you like a voicemail or say we have to talk on the phone about this, that should be your signal that something is happening that maybe is not, fully compliant. All that being said, the FDA can still take action. Things may change, but based on my experience, I don't expect big changes. I want everyone to be prepared for the fact that maybe for the next 6 to 12 months, no big changes will happen in this particular instance. So we have to be prepared to have alternatives for patients, to have a more comprehensive program, which includes something like body contouring and skincare and GLP-1 injections and something else where everything's bundled into one and it's not just a competition on price. Because if the lowest price you're able to get it is from Eli Lilly at $349, it's going to be really hard to, do your $399 a month or $499 a month program. So key takeaways from this, and then we'll do lots of questions. So compounded GLP-1s, they remain legally risky. Nothing has come out to say that any of these deadlines have been extended or there are exceptions. And the big thing to worry about is not the FDA, it's more these big pharmaceutical companies. Make sure to communicate with your patients. So patient communications is really important. We have some model templates for what to say to patients about this and how to manage their expectations and how to talk about the FDA approval and not approval. And make sure to keep in mind this May 22nd deadline. That's really going to be the last day that semaglutide can be compounded legally by certain types of pharmacies. And if you're a member of our firm, make sure to contact us to get updated documents for all these things. It's going to be increasingly important to do that, as I think that probably 10 to 20,000 medical practices in the US are going to get impacted by this from either Eli Lilly or Novo Nordisk. And by impacted, I mean get a cease and desist letter, because I see them doing this in a big way and doing it very strategically where they are contacting both big and small practices, not just in any particular state, but all over the country. So yeah, that was a lot of information. I thank everyone for listening. People always ask me, well, why do you do these webinars? Why are they free? Like, what's the point? And I think that information is power. In my life, there have been so many people who helped me with information, and I want to share it. I don't think every piece of information from a lawyer should be expensive, and I don't think we should gatekeep information from each other. And by sharing this information without charging people, I want to help everyone practice as safely as possible so that we have less regulation, so we have less adverse events, so everyone is on the same page. And that way we protect our industry. So that's my why of doing this. And I'll answer a few questions here. Okay, someone asked, can you please provide an example of a case where a practice has been sued and the cause of action is not a trademark or improper use? I'm very curious what the exact cause of action is that the manufacturer alleges. So the cases that the manufacturers are alleging is that these products are no longer allowed to be compounded. And so they are using a product that's unsafe. And so yes, that may not be a super strong case because the practice may argue, well, the compounded product is very similar. What's so unsafe about it? But I've seen a cause of action like that. Then someone asked, we had a local med spa telling patients that our practice is lying to the public, saying it is illegal. That is absolutely not. And they have no problem getting compounded meds. So they're putting this on social media, trying to get people to go to them. Anything we can do. So you're saying that your competitor is basically selling compounded medication and are telling them, is telling people that what you're saying is wrong. Yeah, I think that's going to happen. I mean, what you can do is I mean, you could report people to the different boards, right? You can report them to Eli Lilly and Novo Nordisk. But I think of it like this. Let's say you're going to spend $2,000 of your money reporting someone. What is a better use of your money? Doing that or spending that $2,000 promoting your own practice? And the reality is the money spent on promoting your own practice is better use of time. So I would suggest forget about this competitor and what they're saying, focus on your practice and promote your own practice. That'll be a better use of your money than, dumping it on some legal letters that may not work. Someone asked, I'm sorry if I missed this, some compounding pharmacies are ceasing production but are still distributing remaining stock. Are we legally allowed to prescribe during that period? For example, patient-specific semaglutide after April 22nd? Great question. It's a bit of a legally gray area. So patient-specific semaglutide after April 22nd, I would say, yes, you can continue an existing treatment plan, but if you're ordering new product for that patient after April 22nd, or your treatment plan is more than 3 to 6 months after that date, that would be very risky. So yes, I think you could continue using existing stock or placing patient-specific orders until today or bulk orders after today, but make sure that it's not for the next 5 years. And if you do have a treatment plan, to make sure that it's documented why this person needs it for the next 12 months or 6 months. So the more documentation you have and the more reasons you have documented, the better. For example, let's say you have a patient, they're on an existing program, make sure to document that program. Make sure to document why they need to continue doing this for the next 9 months, 6 months, 3 months. These types of written documentation will definitely protect you much more than saying, well, we had 500 patients and they all needed this. Someone asked, are the cease and desist letters coming in regular mail or is it a certified letter? Both. And sometimes by email, and sometimes to the wrong address. We've had lots of clients who've gotten letters to their old address, to their home address, to their neighbor's address, not necessarily their neighbor's address, but not the right address. So the pharmaceutical companies are finding people wherever they are, just because maybe you've moved or your address is not public or something like that. They're going to find you. A lot of times they're sending emails these days. But we've seen them send certified letters and regular letters. And then someone asked, are we able to use our existing supply of GLP-1s that patients have in our office? Patient-specific medications that have been brought in advance. Depends on your risk tolerance. So technically, you're not supposed to buy anymore. But if you bought a reasonable supply to finish out people's treatment plans that were already pre-existing before these deadlines, yes. But what is the length of your typical treatment plan? If all your GLP-1 treatment plans are 3 years, but your injectable treatment plans are 6 months or 1 year, you're going to have an issue. So just make sure that, yes, if you're doing this pursuant to a treatment plan to mitigate some of your risk, not all, make sure you have a long and documented treatment plan. And someone else asked, why would the compounding pharmacy's attorneys be so convinced that it's okay to add B12 and it's okay, different enough? It's confusing because our attorneys are saying, no, that's not okay, but their attorneys are saying, yes, it absolutely is. Well, it all comes down to money. If the compounding pharmacy stopped making GLP-1s and that was their one biggest profitable product, they're going to be out of business. So of course they're going to say whatever they need to say in business. So that's why they're saying it. But I showed you the lawsuits. The lawsuits against the compounding pharmacies is the big manufacturer saying adding an ingredient or changing the dose still makes it substantially similar, and that's a problem, and we're still suing you. So I think the compounding pharmacies are saying that they're compliant because they want to stay in business. But at the end of the day, you don't want to have their liability on your hands. So that's why I say it's better to send them a letter if or an email and say, thank you for letting me know that your practice is fully compliant. Can you just confirm, what your legal position is, or put me in touch with your legal team? And they may ignore you. You may not hear back from them, but at least you'll have it documented that you asked. But I don't see a legal way for a compounding pharmacy to add an ingredient or change the dosage and for that to be fully compliant. I see the big pharmaceutical companies coming after them, subpoenaing their records, and then figuring out, oh, okay, this compounding pharmacy sold to these 500 different practices, and then they get one of your names and you get one of these letters. So I think it's risky. We are monitoring this, and I hope to have better news about this at some point. And we're going to do another webinar in a few weeks about this, but this is where things stand. Hopefully you guys found this webinar useful. I'd love any feedback. If you want to send me an email, like I said, my name is Sara Shikhman. I'm the managing partner here at Lengea, and you can find my email online. It's just my first last name at Lengea Law. I'm super thankful to have the opportunity to help people in this industry, and I care super deeply about everyone that I get to help and work with. And I'm grateful to have a little bit of your time this evening, and I will be in touch if I learn of anything new. Thanks, everyone. Have a good rest of your day.